talking about the two main types of patents, which are utility patents and design patents. A utility patent protects how things work. A design patent protects how things look. Now, as you can probably figure out, a utility patent offers most inventors the best protection for their dollar that they can find. So let's talk a little bit about utility patents first. First thing you need to know about utility patents is they have the lowest rate of success in terms of getting issued by the United States Patent and Trademark Office. That, depending on, of course, the latest court decisions and interpretations, vacillates somewhere in the 70% to down to 40%. And obviously this is a factor that the inventors want to take into consideration when filing for a utility patent. Now, because a utility patent protects how something works, it, by necessity, takes a little bit more time on our part and a little more effort than it does to prepare a design patent that protects how something looks. Now, some of the key factors that you should know about utility patents would be, first of all, they don't get examined by the United States Patent and Trademark Office for usually anywhere between 1.5 years to, in some cases, 4.5, 5 years, depending on the type of invention. Now, the rapidity with which the United States Patent and Trademark Office, or USPTO, gets around to examining applications is based partially upon the number of applications that are submitted in that particular area or art unit of the USPTO. It also depends upon the complexity of the inventions, and it depends upon how many examiners they have in that art unit. So, for example, simple mechanical inventions like this 3-membered nutcracker, these usually get examined 1 year to 2 years after the application is filed. On the other hand, a complex software patent, like this one we filed on an auxiliary fuel tank, this one took quite a while to be examined, and I'm really glad that we filed this a few years ago, because if we filed this today, it would probably take 4.5 to 5 years just to be examined, which is one reason why some inventors, particularly in the software field and the complex business method field, like to go for accelerated examination.